Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause SweetP's on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when SweetP's in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Like to with the facts, pretty brown girl with the sass. Morelia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. SweetP's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know SweetP breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. SweetP's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. SweetP says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. SweetP's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Courtroom packed and the cameras on. Folks all whispering won't be long. No more smirks and no more lies. Judge looked down with narrowed eyes. Bailiff waiting by the side door. Steel-toed footsteps on the courtroom floor. Whole chat buzzing like the verdict dropped, but the jury room still got them locked. Hear the cell doors lock. No parole board, baby, round the clock. One-way trip and the bus won't stop. Everybody clap to the L-Wop-Bop, L-Wop-Bop. No appeal gonna save you. Orange jumpsuit, tailor-made flavor. Sink that feeling when the gavel drop. That's the rhythm of the L-Wop-Bop. That's the rhythm of the L-Wop-Bop. Mama crying in the second row. Defense still talking, but it's moving slow. State bought receipts and the pressure's steep. Now the whole room barely even breathes. Used to talk big for the TV lights. Now it's long breaks and uneasy nights. Funny how the swagger disappeared before a single word got cleared. L-Wop-Bop-Bop. Hear the cell doors lock. No parole board, baby, round the clock. One-way trip and the bus won't stop. Everybody clap to the L-Wop-Bop, L-Wop-Bop-Bop. No appeal gonna save you. Orange jumpsuit, tailor-made flavor. Sink that feeling when the gavel drop. That's the rhythm of the L-Wop-Bop. Hey, 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 the L-Wop-Bop. Hey, 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 that's the rhythm of the L-Wop-Bop. Hey. Case pause, courtroom tense. Hey. Everybody waiting on the consequence. One deep hush through the parking lot to the
Oh, good morning, good morning, good morning, everyone. How's everybody doing this morning? Good morning. Oh, well. I know. Hopefully, you won't have to see her for a while. I don't think this is going to be the end of her appeal saga, just so y'all know. But maybe just for a little bit time, we can get rid of her and her faces. Get rid of all of that. Yeah, right. That's what we need to get rid of. Oh, hopefully everybody had a wonderful Sunday. Sunday. Good morning, Lynn. Hey, Amy. Good morning, Christine. Hey, lady. Hello, Marilda. How's everybody doing? Hey, Danielle. What'd you say? I just seen evil in your thing, and that just tells me all as I'm scrolling down. Definitely. Oh, wow. Oh, so if you're working, lurking, twerking, whatever you are doing, I'm glad to have you. Please make sure you hit the like button as you came in. Don't forget to share, right? We're going to share to all our social medias, at least one. You ain't got to share them to all, just one, maybe just one. And yeah, that there. Awesome. I didn't see Gabber. Wait a minute, did I miss Gabber? Well, if Gabber's here, then good morning, Gabber. I didn't think I seen her. I don't know. Or maybe did you change your name? Y'all know y'all don't get to confusing me. It's too early on a Monday. Oh, I see you now. I am so. It's Monday. What a brain fart. You know, I went all the way back up in this thing. Like, I don't see Gabber the Blabber. I'm scrolling up. I'm like, well, maybe she changed her name. Clearly, because I'm like scrolling up. I'm like, I don't see her still. Where's she at? Did she change her name? And went right past her. Well, good morning. Good morning, Phil. Yeah, I definitely need some stronger coffee, right? No, man, oh man. So this lady here, I am gonna put a poll in there because I know that our I know one, you know, the millionaire boat trial, we gotta watch that in delay. So I didn't know how delayed y'all wanted to be with that one, or if y'all just wanted to wait and go into the military trial first. The military trial starts about 9:30. So just so y'all aware. Mountain Standard Time. So we got about an hour and a half until that one starts. So I'll put like a little survey or something, a little poll, so y'all can tell me which one y'all want to go into first. The boat trial has been going on for about a little bit over an hour now. So just so y'all aware on how that's going. Okay, so let's do this. I brought this up because, you know, this was the last hearing where she attempted. Hey, good morning, Susie. This is the last hearing where she attempted this whole, you know, I wasn't well. You know, I didn't know they were putting manslaughter on the table. He basically admitted that I did manslaughter. I didn't want to admit to any of those things. This was that last hearing, and if you don't know, the cross-examination of her in this hearing was so epic, in my opinion. I mean, it was like fire. Like this prosecutor did not play with her at all. So not so much looking at it for the details of Shanda, like the one that we hate. I just like that somebody definitely decided they was gonna rip her a new one, regardless. Like you're just not gonna come in here and say anything. Kind of, no. We're gonna walk down this line. I'm gonna ask you these questions and you're gonna answer them, right? And yeah, let's really get to the nitty gritty of what are you really trying to say? Are you trying to say that he decided to starve himself? Is that what we're doing? Are we blaming Timothy? Oh my God, it was so good. So we're gonna watch that because I thought it was good. Okay, so I do have the opinion and order regarding the new trial. And so we'll read through some of this and then we'll go into looking at her testimony. I just love this prosecutor and how she just didn't hold back, because sometimes they be timid, don't want to raise their voice, don't want to say certain things, don't want to call people out on a bull in court. And this prosecutor was not letting this girl get away with this at all. At all. So I'm going to remove this for a second and I'll pull up the order. Mm. Mm. Oh, shit. I'm trying to see if it will let me. But that don't help me. Trying to get this where it is sized a little better for us. Okay, that look like this is about the best size. Okay, and so you know what our honorable Matthew Kacel. I know he did such a wonderful job on this case, in my opinion. I'm gonna say everything in my opinion because I don't know how other people feel about him. Okay, so the opinion and order regarding a new trial. The defendant was convicted by a jury of 1 count of first-degree felony murder. Let me put my headphones in, or I messed this all up. Okay, and felony murder and 1 count of first-degree child abuse. She was sentenced to life imprisonment without the possibility of parole for the murder and 50 to 100 years for the child abuse. So I guess it's like double life. Following the sentencing, the defendant filed through counsel a motion for a new trial and requested an evidentiary hearing. At a hearing on the motion on July the 25th, 2025, the court rendered opinion from the bench regarding the portion of the defendant's motion dealing with competency. The court stated in the opinion, because they did it like in 2 different parts. The court stated in its opinion was being issued without prejudice and scheduled the remaining issues listed in the defendant's motion for evidentiary hearing. Now, the court has also indicated that it would consider the evidence offered at any future evidentiary hearing to determine if a reconsideration of its decision on this issue of competency was necessary. So the first hearing that we had in July the 25th, and that's when she had her attorney when they talked about how she was, during the trial. Remember her fake, stuff that she did. So we had the evidentiary hearing that was held on November the 25th, 2025 and March 20th, 2026. And the opinion is as follows. Now, you remember in the November 2025 hearing, when we watched that, there's another one where she got in there and she acted like she was sick. Remember, and the judge was like, he was ready to proceed today, and she was with all this extra stuff, acting like she had the major headache of the world and blah, blah, blah. So they end up suspending the hearing. But during that time, testimony from Fred Johnson, her counsel, and they also had testimony from the deputies that actually brought her over there at different points in times. During the first trial. So, remember, this is when she was talking about she was going to make a run for it. I wish she would have made a run for it. That would have been exciting. Exciting. Hey, Cian. Hey, Pretty. How are you guys? Good morning. Yeah, that would have been fun to watch. So, it says first, for the reasons stated on the record on July the 25th, 2025 hearing, the court denies the request for a new trial based on the defendant's lack of competency or the court's alleged failure to observe procedures necessary to protect the defendant's due process right to be competent during trial. The court has considered the additional testimony and evidence from November the 2025 and March 2026 hearings, and after doing so, finds no reason to reconsider or alter its previous opinion. In addition, the court finds that the additional evidence offered at those hearings but rests the finding that there was no bona fide doubt as to the defendant's competency at any stage of the trial proceedings. The testimony of Fred Johnson, defendant's trial counsel, and deputies, Catherine and Timothy, support a finding that although the defendant may have experienced psychological and emotional distress at points during a trial, she still understood the nature of the proceeding and was able to assist her counsel in rendering the defense. The only evidence that contradicts the finding was the testimony of the defendant herself, as discussed below. The court does not find that defendant be a credible witness. My only question when we looking at this, and I'm fine with whatever the judge decides, but I don't know, I guess he's expected to put away his bias, because it almost like when you believe a person is a liar who lies, right? It's really hard for them to come back to be a liar who does not lie. And he determined from the first hearing in the first trial that she was a liar who lies. He actually states that, I think in this hearing he may state it. And I was like, well, if he already thinks she a liar, then there's no way that she can win this, because he's not looking at the evidence, because he knows that he's seen her. He's seen how she is and how she reacts and, the things that she did. So I'm like, well, if you already have that seemed like a bias already. But I don't, and I'm sure that this is not her last stop. I'm sure she can appeal this. She got to be able to appeal this. I can't believe that this would be the last stop for her. I do think that as one of her major issues that she complained about in her when she was requesting her new trial, was her ineffective assistance of counsel rejected. Shanda she claimed that her attorney made several serious mistakes. The judge is going to address each one, in this hearing. And I think he really does question her. So it's not just the prosecution team questioning her. It's also the judge questioning her. Let's listen to you. Let's look at some of it. Only because I just really believe that this brought it out. And I think this really furthered his conviction in regards to her demeanor, who she is as a person, and how she was just trying to play on everybody. Because he definitely, he asked a lot of questions, and I was really surprised.
So we talked about that. He talked about he was putting together a team to work on it. And
can you tell the court what your conversations were with Mr. Johnson?
That first day, we just kind of talked in general. We said from day one that I was going to have to testify. So we talked about that. He talked about he was putting together a team to work on it. And I remember one thing of all the weird things to remember. He asked me what my favorite TV show was, and he was going to have an intern watch it and then come in and tell me about it every week, just to have that time. But there wasn't a whole lot of specifics that day. We were just talking. He asked about my mental health.
Was there any a point in time that you ever conceded your guilt in this case?
Never.
Did you always relay to Mr. Johnson that you were not guilty?
Yes.
All right. Have you ever been charged with anything?
No, I've never even gotten a parking ticket.
Okay. You have testified in this case, correct?
Yes, sir.
Prior to testifying in this case, had you ever testified before?
Yes, sir, when I was a kid.
Or how old were you?
Oh gosh, from age 8 up through, I think about 16 was the last time my biological father tried to get visitation or custody of us.
Okay. Was being charged in this case, can you describe your mental health immediately after being charged?
Oh, horrible. I couldn't eat, I couldn't sleep. I actually didn't eat for 18 days after I got to Muskegon County Jail. It was, I didn't know which way was up.
Just as a bit of a background,
So does anybody have any concerns about her not eating for 18 days? Can you believe that she actually said that on the stand after she was accused, convicted of unaliving her son by starving him to death? Like, do you think anybody cares about you being hungry for 18 days? Who cares? I really think like loose screws up here. That should have been the last thing she should have mentioned. Anything about any food, anything she didn't receive. Like she shouldn't even let nothing like that even come out of her mouth about something dealing with some food or some water or some anything. Like, and who cares? You can miss us with that. Like, don't nobody want to hear about your woe me problems. Girl, bye.
when did you move to Michigan?
2015, I think.
Okay, and
My little guy was like 6 months old.
okay, so it was who moved to Michigan with you?
It was my late husband Adam and little man and myself. That was it.
Okay, and at some point Paul comes to Michigan.
Yes.
Do you recall when that was?
He had just turned 18 and graduated high school, so that was 2020. It was in the middle of COVID.
Okay, and sometime after that, Timothy arrives.
A year later.
Do you remember the month?
I want to say it was the end of May because school had let out.
May of 2021.
Yes, sir.
All right. And I think during your testimony in this trial, he came with like a bag of medications.
A gallon size of blood bag.
All right. What were the medications for?
Well, he was diagnosed ADHD, sensory processing disorder, bipolar, and on the autism spectrum, but he was very high functioning. And so that was, he had, I don't remember the name of any of them really, but there was one that made him like a zombie that he took twice a day. And I think there was probably 8 or 9 medications per day that he was taking.
Why did he move to Michigan?
I got a text from his dad one day that he could no longer deal with him, that Timothy was pushing the buttons. If he did not come to live with me, my ex was going to put his hands on him.
And so that.
And if you were going to bring him there just to put him in a closet, not feed him, not give him any water, if you were going to do that, you should, as far as I'm concerned, I don't know, it might have been better with dad. Like, I don't even understand this. Like, you act like you want to be super saver hoe. Like, what? You putting on your cape and you going to go save somebody only to do something different. And you were not even supposed to have access to him. I mean, like, certain things I just don't think she should even talk about. Because she trying to make it like she was out here saving somebody from a situation with his dad just to bring him to a worse situation. If anything, she should have been telling dad, hey, well, if you can't handle him, please call Child Protective Services because I am in no position to handle him. I feel the same way you do. Whatever it could have been, like, don't bring him back to your house. Like, you were about to do such a great job. And I think they purposely, her and the brother, they brought him back there so they can beat up on him. Like, they just wanted to do this. Like, they wanted to torture him for some reason.
So in May
And asked me to take him yesterday.
From May and when he first arrived, what was his behavior like?
I mean, he was about to turn 15 when we got him, so he was a teenager, but nothing outlandish. I mean, he was trying. He did not care to tell the truth hardly at all. There's no point in asking him a question pretty much the whole time. But he would do stuff. He took my youngest toys at times. He broke a couple of them, and then he took some stuff from Paul. But like, it was just typical teenage. It wasn't anything that we couldn't handle. So.
In January of 2022, a significant event happens.
My late husband Adam had a stroke January 3rd of 2022.
Okay.
It's a massive stroke.
And what was?
Wait a minute. Did she say late husband had a stroke in 2022? So her late husband, he had a stroke and passed away? Let me see. I want to make sure I caught that right, because we might need to open up another investigation. I don't know, because if he was in the house with her, she might have starved him too. I think the only people that was eating in the house was her and Paul.
My late husband Adam had a stroke January 3rd of 2022.
She looked like she almost want to shed a tear for her late husband Paul that passed away in 2022. We might need to get an investigation. He may have survived from the stroke. He just couldn't survive you. Okay.
Okay.
Massive stroke.
And how did that impact the household?
Better question is probably how didn't it? I lost his income. I was already the primary breadwinner, but then I'm the sole breadwinner. We had a babysitting schedule worked out for the little guy, and with Paul and Timothy, at that point we didn't leave Timothy alone with the little one, really. And I was working full time. I was gone because of the location I worked and driving over there and driving back. I was gone from the house 12 hours a day, 5 days a week. So everything just fell apart. I was paying bills on time. I was barely surviving.
Was Timothy being watched by your late husband prior to January?
Yes, him and a little bit. And Paul.
I think you mentioned that in your direct testimony, this was around Mother's Day of 2022. Timothy was about 104 pounds.
Mhm.
Is that yes?
Yes.
And you knew that because you picked up the dog.
He weighed the dog. I could no longer lift. It was a Great Dane puppy that was 7 months old, 6 months old at the time. And the dog weighed 102 pounds. There was no way I could lift that dog.
Okay.
And so he got on the scale, weighed himself, grabbed the dog, got on the scale.
What happens from that day until July 6, 2022?
I mean, from what little I remember, it was the same thing that had started when the stroke happened. Timothy, I remember a couple times, he flat out told me, he said, I'm gonna keep doing stuff until you just let me do what I want. And I said, that's not happening. And it just snowballed. I don't remember a peaceful moment after the stroke for one reason or another. And that's not all, I mean, it was just in general, but he certainly created a lot of it.
He dies on July 6, 2022, correct?
A month before June 16th,
When are you arrested?
July 7th.
And are you immediately taken to the Muskegon County Jail?
You mean on the 7th?
Yes.
Yes, from the North Shores Police Department.
Okay. What were your conditions like in Macomb County Jail, or Muskegon County Jail?
It was awful. I was on max security solely because of my charges, so I was isolated completely by myself in a room.
When you say max security, what was it like?
You're in a room by yourself. You only have the option of getting out of the room into the pod 1 hour a day, so you're locked down 23 hours a day. For me, I was in such bad shape, I couldn't eat. I barely slept. I mean, the whole 17 and a half months there, I might have averaged an hour or two of sleep a night. And there was no mental health treatment. I mean, they tried a couple of meds, but they did nothing. And I kept asking to speak with the doctor, because it was always a social worker. And she said, oh, you're on the waiting list. And I guess the waiting list was longer than 17 and a half months. But I met with her a few times, and she was no help at all. She'd say, oh, I'll meet with you once a week, or I'll meet with you once a month, and that never happened.
So it wasn't because of anything that you did, it was just the nature of your charges that they put you in max?
That's the only reason, yes.
How often, did you have mental health issues prior to that?
I have severe ADHD, and I have sensory processing disorder, and a little bit of OCD. I guess it was a month after I got to Huron Valley, I was diagnosed bipolar, which I've had my whole life, I guess, and didn't know it. But at the time, I just knew about the ADHD and sensory processing.
How often during this time period would you see Mr. Johnson? From the time that you're incarcerated to the time?
The first month I saw him 2 or 3 times, but after that it was every once in a blue moon. I think he said it was once every other month. It didn't even seem like that often.
During your conversations with him, were you talking trial strategy?
A little bit. We didn't a lot, but we did a little bit.
Was it ever, tell me what the strategy was.
Well, on the child abuse charge, it was intentionally and knowingly. And that was, without that, the felony murder charge was gone. And so that's where we focused. It was never on I didn't even realize second degree would be an option until the day of jury selection. So we focused on the intentionally knowingly from that, because that cost the felony murder charge.
Did you know manslaughter was an option?
We never talked about second degree or manslaughter until the day of jury selection. It was on the jury instructions for second degree. And then the last morning, when I had the breakdown, I vaguely remember him coming in and saying he got these instructions added. And I I had no clue what to say. I was in bad shape, so.
Well, tell me about, I mean, you testified,
Yes.
and tell the court how you felt during your testimony.
Well, before the testimony started, this was one of the things that really shocked me. While the medical examiner was testifying, Fred was writing down questions. He had not had any
Objection,
questions.
non-responsive. Sustained.
How were you feeling during your testimony?
Why she make that face like man, her and these faces. Why she make that face like that? Like somebody had did something to her. Oh gosh. Oh, I can't wait till this prosecutor get up here. Oh gosh. I almost want to skip through everything, but we just need to see how the difference in her demeanor when she's on the stand. That's the reason why shout out to Susie. Susie said, good morning, happy Monday. She is turning people, girl, breathe. Make sure you say thank you to Susie. You received that gifted membership. Thank you so much, Susie, for your continuous support. Oh, welcome in.
Stressed, panicked, scared, terrified.
Okay. And after, how did your testimony end on that third day of trial?
I believe they were talking about jury questions, and I had a really bad panic attack.
Okay. And what happens after that?
Well, I had been in the room by myself in a pod.
Well, I mean, from the time that you leave the courtroom, this courtroom.
Yeah. Instead of going back to the pod, I guess the sheriff had decided to put me back down in holding instead of where I had been, where there was at least people around, even though I couldn't come out to see them.
Are you talking, okay, so you're talking about in this
In the
building?
Stephen County Jail, yeah.
Oh, at the building, okay.
Yeah. So he separated me completely down in holding. And
Did Mr. Johnson talk to you after that, on that third day? Okay. And what happens at the jail over the course of the night?
well, I remember right after I got back, I mean, I was upset at the whole being separated, holding, the lights don't dim. The noise level was horrible, and I was trying to think through trial stuff just to keep myself occupied. I had thought of some questions I wanted him to come back and try to ask me the next day. But then I might have, I don't know if I even slept for an hour that night, but I remember that when I was, I don't want to say come to, when I was functioning, I was curled in a ball. I was freaking the heck out. I couldn't, when they first came to get me, I said, I can't even go. I can't leave the room. And they're like, well, you have to, come on. And it just.
How were you taken from the jail to the courthouse? Or the courtroom?
Well, we went to, I guess, where I changed clothes, and that's as far as I got. But it's, I mean, we walked over there.
Okay. We heard, you were in the courtroom when we heard some testimony that you were curled up in a ball. Is that accurate?
Yes.
Were you suicidal?
I don't remember saying it, but yes, apparently I made at least one comment that I was gonna kill myself.
All right. I mean, sounds pretty drastic. What else do you remember from that morning?
I remember just being sheer panic. I was frozen, like I couldn't even move. I remember laying up against the wall on the floor on my side on one of the concrete benches in one of the holding rooms that they tried to come upstairs, and I couldn't do it. And so I went in there and curled up in a ball on my side. I was completely paralyzed. My brain was not working. Anytime I even thought about anything, I wanted to panic, and I had several panic attacks during that time.
Do you recall talking with Mr. Johnson during this time?
A little bit, yes, sir.
What was the nature of your conversation? Or was he talking to you, you talking back, or what was it, how was it going?
I remember at one point he came in and said that he had fought for a while to get the involuntary manslaughter instructions put on, and I remember thinking, what's that got to do with anything? And then I specifically asked him, after we tried to go upstairs, I said, look, can we please adjourn this? I can't do this today. And I asked him several times, and he made a comment. He said, oh, it'll just be the same way if we do that. You're gonna have the same issue. And then he said, well, we'll just go on without you, and then he left.
Do you recall signing the document? You've seen it since though?
Yes.
All right. Is that your signature or not?
I mean, it looks like it. It looks like a version of it.
Okay. But you don't recall signing? Is that a no?
No, sorry.
Did any medical personnel come to talk to you when you were in your condition?
No, sir.
When you were testifying on that third day, did you ever concede that you were guilty of anything?
No, not for a second.
And as far as you knew, Mr. Johnson knew what your position was.
Oh, yes,
And what was that?
that I was not guilty. We had a visit. It was one of the last couple of visits I had with him, and he was actually the one that stated, we've been talking about the intentionally knowingly, and he said, they don't have intentionally and knowingly, you're not guilty. And I
Okay.
clung to that.
And the intentionally and knowingly phrase that relates to the first degree child
Yes, sir.
abuse. And in your understanding, the ultimate charge was felony murder.
Yes, sir.
And the predicate offense was the first degree child.
Yes, sir.
All right. I don't have any further questions.
I know y'all cannot wait for our girl to get up here and get at her, but I just want to, as we going through that part, just so you know what she's trying to say here, right? And how the judge broke it down in his order. Okay, so now in the remaining matter of the court is the defendant's argument that she was denied effective assistance of counsel during the trial. So he goes on to say that the purpose of effective assistance guarantee of the Sixth Amendment is not to improve the quality of the legal representation. The purpose is simply just to ensure that criminal defendants receive a fair trial. And then he cites Strickland versus Washington. To demonstrate the denial of effective assistance of counsel, a defendant must first show that the trial counsel's performance was deficient, or that the performance fell below an objective standard of reasonableness, such as counsel was not functioning as the counsel, which is guaranteed by the Sixth Amendment. The defendant bears the burden of proving that the counsel's representation was unreasonable under prevailing professional norms and that the challenged action was not sound trial strategy. So basically that his strategy, it didn't make sense with what they were doing. There's a strong presumption that the performance was reasonably professional. So as we can see, and we just heard, the defendant first alleges that Mr. Johnson, which is her attorney, was deficient by allowing the trial to proceed, knowing that his client was incompetent. So she's saying that she was so incompetent that this trial should have never went on. She also argues that Mr. Johnson allowed her to sign that written waiver of her right to be present during the trial, knowing she was incompetent. This assertion is contradicted by the testimony of Mr. Johnson as well as other witnesses. Melissa, she is the master's level social worker assisting with the defendant's case. Both Mr. Johnson and Melissa had extensive interactions with the defendant throughout the trial, and in particular, the morning of December 15, 2023. So Melissa also testified in a hearing in the first hearing that they had in November of 2025. Okay. So it says Melissa's testimony was particularly compelling to the court given her educational and professional experience in the field of social work. She testified that on the morning of December 15th, the defendant was very anxious and had pressured speech, but did not appear to be experiencing any psychosis or catatonic or anything like that. So Ms. Melissa also testified that the defendant was oriented and that she knew who she was. She knew she was in trial. She knew that witnesses were going to be called. And as to the waiver, Melissa is saying that the defendant appeared to understand the concept of the waiver of the courtroom presence and clearly expressed her desire to exercise that option because she didn't want to, and personally, this is my personal thing, this is not in there. And that's because she didn't want to face that this part was coming to an end. She didn't want to see any more of this bad evidence that was coming in for her or hear the jury's decision or the verdict or anything like that. And that's why she waived it. It had nothing to do with anything else. But that's my personal thing. The defendant, according to Melissa, was apparently appreciative of the waiver being offered because she didn't want to come back to her. And she was relieved she did not have to appear in court again. She was happy she didn't have to face this stuff. Mr. Johnson's testimony was substantial, and it was very similar to Melissa's. So the defendant's testimony on the issue was unconvincing. So her recollection of events, remember, when we getting into this trial now, on the morning of December 15th, just listen out how she tries to explain this away to the judge, and the judge wasn't feeling it, was clouded by self-proclaimed lapses of consciousness that only occurred during critical times during the trial, which could conclude as issues of her competency. Now, this self-serving, and yes, he does says, this self-serving amnesia was substantially similar to her in the trial testimony when she claimed she could not remember her interactions or communications with the co-defendant that would support criminal culpability, but could recall most of the events surrounding the death of her son. To put it bluntly, she is an incredible historian. The court finds that Mr. Johnson's conduct as to the defendant's competency was not unreasonable and was sound. Let's see. Did we talk about this one? Okay. The defendant also argues that Mr. Johnson was ineffective because he failed to search for or call an expert witness who could support the defendant's assertion that she lost her memory and it was legitimate and result in an underlying mental illness. Now, he tried to find somebody to come and testify on her behalf, but if I'm not mistaken, the expert was like, all they can get up there and say is that she was purely evil. So she's saying because he couldn't find somebody to support her lies and get up on the stand and risk their career, you know, she was trying to find somebody like TT found in her trial that was just gonna get up there and say, oh, anything on her behalf to support her, that he was ineffective. So despite this assertion, the record demonstrates that the defendant was evaluated by 3 potential experts. And then he lists them. The examinations were performed by separate physicians. The reports that were generated following those examinations would not have been favorable to the defense. Like, he couldn't find nobody to support your lies. Like, everybody, they should have called TT's doctor. TT's doctor would have came in there and did it. She wouldn't have cared. I can't remember her name, but she would have came in there and did it and would have been okay with it. Like, okay, no problem. So, despite this assertion, the records demonstrate that the defendant was evaluated by these 3 experts. Let's see. The reports indicated that the defendant's claim of amnesia were not medically supported and appeared to be selective, right? So it didn't support anything that she was talking about. And that's why he didn't call them to the stand, because they wouldn't have been able to support her theory anyways. The defendant next argues that Mr. Johnson committed prejudicial error by failing to highlight the dehydration as the cause of the victim's death. So what she want to say is that maybe that he was dehydrated and that's why he passed away. Mr. Johnson's avoidance of this issue was not accidental, but it was intentional. He testified that his strategy of the trial was to focus on the issue of the intent versus negligence and not on the cause of the victim's deaths. So that's what's going on. So let's see here. Specifically, he wanted to convince the jury that the defendant did not form in her mind the intent to harm or cause injury to the victim. So that was what he was concentrating on. Okay, so that just gives you an idea as we going through here what things the judge kind of broke those down one by one. Okay, now we're gonna go into this cross-examination and let's see how this goes. It was such a good cross-examination.
Is it all right if I move the podium?
You may.
Morning. So, Ms. Vander Ark, I just want to go back and ask you a little bit about your background, okay? So, were you a legal clerk, or what was your exact role at Nuevo County Circuit Court?
I was a law clerk.
Okay. And you were previously an intern in Muskegon County Circuit Court, correct? What were some of your job duties in those 2 positions?
Oh, sorry. Well, both of them. I did legal research. I helped score sentencing to make sure it was accurate. That was about the extent of it here, because I was still in law school. When I worked for my judge in Waco, I actually did the research, and I would draft opinions, and then he would, decide if that was okay. And most of the time, he just signed off on I'd gotten it correct.
Is it fair to say that you worked on post-conviction motions for your judges,
Yes, I did several times.
including claims of ineffective assistance of counsel?
I would assume so. I don't remember.
And so in other defendants' cases, you would be writing draft opinions or bench memos for circuit court judges.
That's what I wrote. I don't think we had an ineffective assistance. I don't think so. I may be wrong, but I don't think so.
And it's your testimony that your opinions or your recommendation to the judge was so good, he just wrote off on it? Signed on?
Most of the time, there was a few that he adjusted, but he would read them and then send them over to his clerk to publish, so.
And this all happened before you were criminally charged, correct?
Yes.
So even before you were at a trial, you are intimately familiar with post-conviction motions, correct?
I wouldn't say intimately familiar. Some of them I was familiar with, but.
Familiar enough for your judge to just rubber stamp what you said?
A lot of what we did, actually, most of what we did was civil. There was some criminal, but most of the motions and the work I did as part of writing was civil. He did both civil and criminal.
Now, Ms. Vander, you mentioned that Mr. Johnson had a team of individuals at the Public Defender's Office, correct?
Yes.
And could you tell the judge how many individuals were on that team?
I have no idea. I think total I met with over time, probably 6. And then he mentioned having somebody doing research and other people and other interns working on it, but that's the people I met with. I don't know how many there were.
It wasn't just you and Mr. Johnson working on the case though. He had social workers that assisted you, and it sounds like interns as well,
Yes.
and other attorneys in his office.
Yes, I only met, as far as the criminal side, I only met with another attorney in his office. It was at one hearing, it was the gentleman that sat second chair, and then at trial. I didn't meet with any of the other attorneys otherwise.
And you said that Mr. Johnson began meeting with you approximately 2 days after your arrest,
Yes,
and he continued to meet with you throughout the pendency of the case,
yes.
and his team would meet with you throughout the pendency of the case.
And the social worker is the one I saw the most. I'm trying to think, I saw the intern some, but that was mostly it.
And when you say the social worker, do you recall, was that Melinda Pateki?
For the last 2 visits, I only saw her twice in person. And I think she was online once for a meeting with the doctor. But there's another social worker that met with me once a week, usually for the first few months, I don't know, probably 6 months at least, and then she moved on from the office.
Now, Ms. Vander Ark, you've spoken quite a bit this morning about your medical, I guess, episode, for lack of a better term, medical episode that happened mid-trial. Okay, so I'm gonna go into that. But that's not the first episode you had during these proceedings, correct? Okay. And one of those happened at your preliminary hearing, or your preliminary examination, correct? And that occurred just before Paul was going to testify at the prelim, correct?
I believe so.
And your medical episode that happened in the trial happened right when you'd been confronted during cross-examination, correct?
I had one other one before, during trial.
Okay, when was that?
There were some police officers testifying.
And it's
I
your,
was sitting there and had a panic attack, and they cleared the jury out.
and do you recall what the officer was testifying about when you had that episode? Probably something pretty significant about your case though, correct?
I mean, I would assume so.
Or something about your son's condition?
I don't know.
It's fair to say that those episodes though don't happen all the time.
They do, well, they were beforehand and they still do happen this year.
That's a poorly worded question, so I'll clarify here. Those episodes didn't happen on direct examination with your own attorney questioning you, correct?
They didn't happen
They didn't happen during opening statements?
No.
Or jury selection? No? They didn't happen during certain parts of your preliminary examination?
No.
But these episodes happen when you're confronted with evidence that you don't want to acknowledge or admit. Is that fair?
No, they happened when I was confronted with traumatic events. It was anything traumatic that got that bad.
So seeing your son, who was in your care for all those months, in a picture, was traumatic to you?
Yes, extremely.
But you'd seen him every day that he was in your care, correct?
Yes, what I remembered, yes.
And then when you see a picture of him on that stand is when you have this episode.
Yes, I mean, I had panic attacks. Looking back, I know I had panic attacks previously, but I don't know what brought those on.
Nobody diagnosed you with a panic attack on the night of that trial, correct?
I don't know.
That's a yes or no.
I said I don't know.
You have no evidence that you had medical diagnosis of a panic attack that day.
That day? No, as far as I know.
And you have no medical diagnosis that you had a panic attack during your preliminary examination, correct?
There was no medical person called in.
Okay, so my question was, you don't have medical documentation of a panic attack that day?
No.
So let's talk about some medical documentation you do have. If you recall, Mr. Johnson submitted you to multiple individuals for forensic examination.
Yes.
And you met with those medical providers?
Yes.
And how many would you say, based on your memory, you met with?
Couple.
Okay. Would it surprise you that there's approximately 4 reports regarding your criminal responsibility or competency?
No,
That wouldn't surprise you?
no, because I understand the process, so it doesn't surprise me.
Okay. What's your understanding of the process?
That both sides can get the competency evaluation and responsibility evaluation.
And you understand that under Michigan law, you're presumed competent unless proven otherwise, or unless shown otherwise, correct? Okay. You've never been shown to be incompetent, correct?
Not medically, no.
No, not legally. Is that correct?
Yeah.
You have never had a legal determination that you are incompetent, correct?
Yep.
And that's after meeting with these 4 providers, correct?
Yes.
And in fact, some of the providers called into question your rendition of facts to present to them. Do you recall that?
I don't recall that, but I'll trust if they said that.
Do you recall specifically? Let me go back here before we get to that. Do you remember your interviews with these providers?
Bits and pieces.
Do you feel that you were truthful with them?
Yes.
Do you feel that you appropriately explained your situation and your memory with them?
I hope so.
But you don't know, correct?
No, I don't.
Sorry, bear with me one moment, please. Here, I'm referencing People's Exhibit 2, which I believe was attached to my brief, which would be a June 20th, 2023 report authored by a Benjamin La Liberty, doctor. Now, did you tell this doctor or this individual at the Department of Health and Human Services Center for Forensic Psychiatry that you disassociated during times that Timothy was in your care?
Yes, even times when he wasn't. I mean, it happened regularly, it still does.
Well, and that's my question. So is your claim in this post-conviction motion that you were disassociating during parts of the trial?
I mean, I'm not a medical person, so I don't know, but that's the only answer I have.
Well, so I'm not asking you to give me a medical opinion. I'm asking you to tell me what you mean when you're saying you disassociate. So what do you mean when you say you disassociate?
Usually it's a panic attack and I have no clue what's going on around me. I don't remember anything during that.
And so you've said that on that day of trial, when you had your episode, that you had a panic attack. But would that be a disassociation like you have just described?
During the panic attack, yes. They usually only last like 10, maybe 15 minutes.
Oh, okay.
Just one question. I just want to interject. This, can you describe to the court what you believe a panic, what you are experiencing, so what you call panic attack? What are you experiencing during this event that you label as a panic attack?
It's one of two things on the breathe. Either I hyperventilate, I feel like I've got an elephant sitting in my chest and crushing me and I can't breathe.
So that's trouble breathing?
Yes. I'm shaking, my head is totally spinning.
So dizziness?
Yes, sir. I don't have a clue what's going on around me. I know people have tried to touch me during panic attack and that just makes me all worse.
You mean painful?
No, just trying to make sure I'm okay.
So when somebody touches you, what do you experience when someone touches you?
I pull away and the panic gets worse
Okay, so you're aware of somebody touching you?
when they actually put their hands on me, yes.
Okay. When you say you don't know what's going on around you, is it you have auditory problems where you can't hear, or you just have an inability to understand what's being said?
I think it's both. I mean, I don't remember anything that's been said to me during the panic attack. I know I had a couple people scare me at Huron Valley. They were just playing around, but it caused a panic attack because I didn't know they were there. And I guess they tried to talk to me and they said, yeah, we got no response. And I don't remember them trying to talk to me at all.
Okay.
It's like I'm down
Any
there.
other symptoms?
It's like I go into a total darkness, this black hole.
Okay, no, when you say darkness, are you seeing black? What are you seeing? Is it
Like the black
spots?
or gray, usually. I'll try to fix on a spot as it sets in, but then that's it. I don't see anything else.
Can you move? Are you able to move your arms, legs, extremities?
It's not most of the time, no. I'll curl up into a ball.
So let me ask you a question. You curl in a ball, you consciously make the decision to curl into a ball to stop the symptoms? Or is it an involuntary movement into a ball?
It's an involuntary movement.
So involuntary movement into a ball. And then you don't know how much time passes?
No,
Is that what you're telling me? Okay.
no. I know that afterwards, I've had somebody there and looked at the clock, and the only thing I could tell you has been, I've had people say like 10 to 15 minutes.
And you said these have happened while incarcerated currently?
Yes.
Okay.
I still have to
In your cell, in your common areas, where they happen?
most of the time it's in my room
In your cell,
or in the restroom, yeah.
room or restroom? Okay. Any times when other inmates were around?
Yes,
Okay. So common areas?
yes,
Okay. And you're aware that these areas are filmed, correct?
yes,
So this would be on camera?
Yep.
Okay, so you're telling me that you experienced a panic attack where you curled in a ball on camera at the prison?
yes. In the foyer of one of my units, somebody came up behind me and scared me.
Do you know approximately when that was?
I have no, well, I can give you a date range because there was a certain time I was in that unit.
All right, please
It
do
would
so.
be somewhere between the end of August of 24, and, beginning of January of 2025. That was the time I was in there.
All right, thank you. I just want to make sure we understand each other about the next. Go ahead, Ms. Blue.
Let me clarify, you said August of 2024 through January of 2025?
See right there, that was very important, I believe, in the judge's decision. He got that time frame out and he asked her, he was like, okay, so the common areas, they are recorded. And you're telling me that you would fall down, ball up in the ball, whatever. You sure? You know that those areas are recorded. So all they could tell me right then is that the judge is making mental note. Okay, you're saying this is when it happened. Okay, I'm gonna go back and pull the film. That's all that's exactly what that meant. I bet you went back and pulled that film and wasn't nothing on there the entire time that she was there, because I'm pretty sure somebody would have to have an incident log. They would have wrote down something happened. Something would be documented somewhere if her incident or her blackout, her falling out, whatever she want to claim actually happened, and somebody would have to put that in an incident log, because she would need to go seek medical treatment to a certain degree. But she want to make this convenient. Like, I be like, if you gonna do it and you gonna say it, I like almost need you to go all the way in. So like when the judge is asking her these questions and she going through this right now in her mind, she should be pre-gaming on how she about to fall out in court right now. Like, she should have fell out on direct. I don't know. Like, she maybe not fall out on cross, but fall out on direct. Like, so you can disprove them saying, hey, no, I don't always get anxious. I don't always get nervous when I'm on cross-examination. I just fell out on direct examination. Like, if you go play the role, baby, you better play it. That's all I got to say. Like, don't half step it. Y'all know like, don't half step it. Like, if you go do it, I want you to do it. And I mean, do it. So if you're going to be claiming it, I want you to do it all the way. I want you to show me how much you can act it out. Like during that first hearing, when the judge asked her for a continuance, and when she asked the judge for a continuance because of her headache, that was the perfect opportunity to fall all the way out. Like she want to hold her pride to certain things, but she don't want to like do it. Like do it. And my whole thing is like, stand on business, man. Like if you gonna create the lie and the illusion, do it when it's most convenient. Like when the judge kept telling her he wanted to go on with the hearing, and she was talking about her head hurt. And remember the first hearing, they took her out and they let her get some medication. She came back. She was still sitting up there like she couldn't do it. Like, why not just fall out? Just fall straight out. Like, I would have fell right out. Like, this is the play I'm playing, no matter whether y'all like it or not. But if this is the play I'm playing, I'm falling all the way out the chair. Let's stop this here. Like, so I can have that to add. Like, I did this in front of you. Like, Judge, you seen this happen. Literally. Like, you seen it happen in front of you. So now you really don't need to go look at the camera because I'm about to fall out right now. Oh my goodness. I'm telling you. Hey, Martina. Yeah, she don't know how to play the game. Because I'm telling you, I will play the game. Like I don't think she ever cried, nothing. Have y'all seen her cry at all? I haven't seen her cry for him, cry for her, cry for the dog down the street, cry for Paul, cry for the baby that she left. I haven't seen her cry not once. In none of these hearings, have y'all seen her cry? Oh my goodness.
I can give you the name of the unit.
Yes, that would be helpful.
Gladwin.
So, Ms. Vander Ark, now it seems like we're all on the same page about what you mean when you say panic or disassociate.
Yes.
Okay. And it's fair to say it's your testimony that you had that sort of episode mid-trial during your cross-examination. Is that your testimony?
Yes.
Now, are you aware, though, in People's Exhibit 2, that criminal responsibility report that I previously placed in the record, that it was noted by the clinician that your claims of disassociating, quote, only occurred when Timothy was bad? Are you aware of that in the report?
I'm not, because that's not true.
Okay. And overall, the opinion of the clinician was that when you described your current state, you did not describe any substantial functional impairments within the context of your current confinement.
If I said that, that's not true.
Well, that was his opinion.
That was his opinion? Okay.
Yeah.
I didn't know I said that, so that's.
And here, let's go further. On page 10, Your Honor, if I may approach. I'm showing the witness People's Exhibit 2, page 10. Ms. Vander Ark, you would look at that, and would you read right where that star starts? Please read that into the record.
Ms. Vander Ark was asked to recount her thoughts, feelings, and behaviors around the time of the alleged offense. However, Ms. Vander Ark claimed to have no memory of the events that led to Timothy's death, noting she frequently dissociated due to the stress of interacting with him.
And you can keep reading. Please read the whole paragraph.
Of note, this immediately appeared to be a self-protective response style as opposed to the result of a genuine memory deficit or bona fide dissociative condition. That is, her purported memory loss was noticeably selective and only involved the actions that allegedly caused the victim's passing. Thus, Ms. Vander Ark cannot be considered a credible historian. It's not true.
So, Ms. Vander Ark, we don't have an opinion from an expert that you were incompetent, correct?
Yes.
But we do have an opinion from an expert that you're not a credible historian, correct?
Looks like it.
And that's specifically as it relates to your credibility about these disassociations you claim to have, correct?
That I have, yes.
That you claim to have, correct? Have you been diagnosed medically in any of these reports with a dissociative condition?
Not in those reports, no.
Now, you, one of your claims in this post-conviction motion is that you take issue with Mr. Johnson not calling an expert, correct?
If that's what's in there, then we discussed it briefly. I didn't know what he was doing. So as far as if he was gonna call him or not.
So I just want to make sure I'm clear. You weren't sure if Mr. Johnson was going to call the expert or if we weren't going to have the expert here at this hearing? This one?
For a while, I wasn't sure if he was gonna call him at the trial.
Okay. But you do recall meeting with Dr. King, correct? Yes. Okay. How did you feel that meeting went with Dr. King?
Long,
Was it thorough?
I would assume so, yeah. I mean, I don't remember the whole thing, but I know it was exhausting.
Now Dr. King also has some opinions as it relates to your credibility as a historian, correct?
I don't know.
You don't know? Okay. So I'm looking here at Defendant's Exhibit B, page 10. And Ms. Vander Ark, I'm going to just start here where it says conclusion. Ms. Vander Ark overreported general psychological dysfunction and generated a larger than average number of infrequent responses. Are you aware that that was determined based on your psychological testing?
I mean, I think I've read it before.
Okay, you have no reason to dispute what he has in this report.
I'm not disputing.
In fact, you actually attached this report to your motion for a new trial, correct?
Yeah, my attorney did it.
On your behalf, though,
Yes.
correct? Yes. And so we have one clinician saying that you're not a credible historian and another saying that you overreport general psychological dysfunction, correct?
That's what they say.
Ms. Vander Ark, there is no medical opinion now that determined you were not competent to proceed with trial, correct?
Correct.
You have no medical evidence today that you presented at this hearing, correct?
Correct. Nobody bothered getting it.
Your Honor, I move to strike that non-responsive answer from the record.
I will.
Thank
It is non-responsive.
So I'm going to shift gears here a little bit. In your direct examination, you've provided multiple other individuals that you want to place blame on for what happened in your criminal case. Is that fair to say?
I mean, I'm not gonna dispute it, yes. I don't remember all that testimony.
Well, just today. Today you said that it was your ex-husband's fault that Timothy came into your care, correct?
Well, he asked me, yes. That's what he told me, and that's why I told him.
And it's your testimony that it's the jail's fault for your housing situation that exacerbated your mental health, correct?
I didn't have any choice in the matter, so
So
yes.
that's a yes or no. Are you blaming the jail for your mental health?
For making it worse, yes.
So we have, you're blaming the jail, you're blaming your ex-husband. Now, you've also blamed Timothy today, didn't you?
As far as what?
As far as his behavior is causing you to act the way you acted.
As far as causing chaos, yes. I mean, as far as causing stress, yes.
And now you blamed work as well, saying that caused stress. Your employment before your arrest.
I mean, work always causes stress.
This has been a consistent theme for you, where you want to blame others for things you've done, correct?
Explain the situation.
Well, so you're saying it's your ex-husband's fault, it's the jail's fault, it's Timothy's fault, It's now your trial attorney's fault that we're here. So is it fair to say it's a theme of yours to point the finger at others for what's going on in your case?
I wouldn't say it's a theme, no. That's an opinion. I can see
All right.
the things that I had no say in, that you can't blame me for.
Now let's talk about those jail, the testimony you had about your being held in, you said it was max security during the pretrial phase, correct? You said you were locked in there and isolated?
In a room by myself, yes.
Okay, yes. Was Timothy also locked in a room and isolated when you locked him in the closet?
He wasn't locked in, but he was in the room, yes.
Okay. When you had alarms on his door to keep him in that closet, was he isolated?
Yes,
And he'd be locked in there for hours at a time, correct?
I would assume so, yes. I don't,
Yes or no? Was he locked in there for hours at a time?
yes,
And you want the court to use your isolation as a basis for making a determination about your mental health, correct?
it has an effect on it, yes, it does.
What about Timothy's mental health? What impact did your locking him away, isolated, have on his mental health?
I have no idea how to answer that.
Truthfully, it's what you're here to
That
do.
is truthfully, I have no idea how to answer that.
Now, you talked about some of his diagnoses, correct?
Yes,
Obviously, it wouldn't be beneficial to him to be isolated like that, correct?
yes. I mean, he isolated himself too. He did not. I offered to, there were kids in the neighborhood, and I actually specifically asked them. He wasn't the most coordinated kid in the world, but they were playing basketball one day, and I said, hey, can you come over? They said, anytime. He never wanted to do that. When we went to Little Man's baseball games, he stuck to himself or with us. He didn't want to go talk to the older kids.
So it's your testimony that Timothy isolated himself.
Some of the time. Not all the time, but some of the time.
Timothy, who you went to such lengths to keep away from your in-laws that you were tracking their location so that your child G would be outside when his grandparents arrived, is the one that isolated himself.
I did not. That was not the point of finding out where mom was. It was because the house was a mess. It wasn't, it had nothing to do with Timothy. That thought it hadn't even entered my mind until I got asked about it as a child.
You expect the judge to believe that Timothy did this to himself, correct?
Can you define
Well,
that?
that's what your testimony is that he isolated himself.
I said some of the time, and you said this, that's
Okay, I'll clarify. He isolated himself in that closet
some of the time. Some of the times downstairs,
where he had nothing but a tarp in there. He isolated himself in there. Is that your testimony?
he tore apart the mattress. But
That was not an answer.
some
My
of the
question.
time, I said some of the time.
Did he isolate himself in those ice baths?
I wasn't there for that.
But you ordered it, correct?
I don't remember.
You had a cell phone at the time this happened, right?
Yes,
And you were messaging with your other son, Paul, correct?
yes.
And those messages speak for themselves,
I'm
right?
not disputing the messages. I'm just telling you what I do and don't want to do.
Now, you testified earlier today that during the time after your husband's stroke, you were, quote, barely surviving. Do you remember testifying to that?
Yes,
You were surviving just fine. It was Timothy that was barely surviving, correct?
I wasn't aware of enough of what was going on around me. I wasn't, I admit that.
Now, another claim in your post-conviction motion is how your attorney, Mr. Johnson, handled the surveillance video from that closet, correct?
The emotion about it, yes. Oh, yes, I know what you're talking about, yes.
Okay. And so you are claiming that it was ineffective or deficient of Mr. Johnson to let the police officer testify to the contents of that video, correct?
I mean, if that's what's, I trust my attorney with that, so.
Did you observe that video?
No.
You were in that video though, to your knowledge, correct?
As far as I know, yes.
And that video has been described by multiple individuals as extremely graphic and haunting. Are you aware of that?
I think I've heard that, yes.
And that video actually, in fact, shows your son take his final breath. Are you aware of that?
I did not know that.
And it shows what you were doing in the time leading up to him taking that final breath. Are you aware of that?
I would assume so.
Are you aware that it shows you being extremely cruel to him in those moments?
I don't know.
You're also aware that after he's passed away, it depicts you dragging him out of that closet. Are you aware of that?
I remember performing CPR, so I guess was what happened before that.
Okay, one second. Thank you. Are you aware that at the end of that video, after you pull him out, there's audio about telling him to stop faking it?
I have no idea what it was.
Are you also aware that before he passes away, you call him a dummy?
There was something said about that at trial. They all say stupid things.
So it's your testimony that that was just a stupid thing to say to your dying son? To insult him?
It's a stupid thing to say to your child, period.
Yet you said it, correct?
Yes, I mean, I'm not disputing it.
Do you believe that your attorney should have let the jury view that video in its entirety?
No,
Okay. So you think it's probably a good trial strategy to shield the jurors from seeing you on video insult your dying son, correct?
yes,
It's probably a good trial strategy to not have the jurors personally witness his last breaths, correct?
yes,
And it's probably a good trial strategy to not have the jurors observe you telling him he's faking it when he's already dead, correct?
yes.
Now, it's your testimony that during the trial, there was some discussion about the manslaughter instruction, correct?
What do you mean? I'm sorry, can you rephrase that?
So you testified on direct that when Mr. Johnson came to the jail, he was discussing jury instructions
Wait,
with,
this hearing, yes, I'm sorry.
I'm sorry, not this hearing, I apologize, the trial. During the trial, there was a discussion that Mr. Johnson had with you about the manslaughter instruction.
Yes,
I'm going to ask a couple of questions that sort of dovetail off of the court's questions here, though. And I'm sorry to go backwards, but you said when you're having these dissociative episodes, you have involuntary movements. I'm sorry, it's being recorded, so is that
I'm
yes?
sorry.
And let me ask you this, was it an involuntary movement for you to grab the garbage can while you were testifying? Or was that not intentional?
I don't know what you mean. I mean, I was gonna throw up, but
Okay, so did you make the choice to extend your arms and grab it?
yeah,
And did you make the choice to lean your body over?
I don't know. I was, I don't know. I mean, I just
Oh.
throw up, so,
Did it happen by accident that you were positioned that way?
I mean, no.
Okay. Are you aware there was no vomit in that garbage can once you left the courtroom?
I have no idea.
It's because you faked the vomit, correct?
I didn't fake anything. I dry heave all the time. I dry heave from motion sickness before I got the motion sickness meds I used this morning for the trip over.
Okay, let's talk about that. So didn't you claim at the last hearing that you had some motion sickness on the way into court?
Yes, I did.
And do you recall whether or not that was supported by any of your transport team?
I remember they said that they had glanced at me in the mirror. I mean, I know I was dry heaving. I didn't actually throw up anything, but that's because I didn't eat intentionally.
Do you- Okay, so do you remember, I believe there was some in-court inquiry to your Department of Corrections, corrections officers. Do you remember them saying something from these seats back here at the last hearing?
I remember them talking from there, yes.
Okay, and I believe the judge, and I don't have the transcript, but I believe the court may have even sworn them in briefly for a couple of them.
Yes.
One of them, yes. And it was as to your claims of motion sickness, or how you were feeling on the transport,
I
correct?
was feeling of transport, yes.
And there was no mention of you vomiting in that transport van, correct?
No, I dry heaved. I didn't have anything in my stomach to throw up.
Ms. Vander Ark, you were here for that November hearing, correct?
Yes,
And you sat in the courtroom while the other witnesses testified, correct?
yes.
Is it your testimony today that they all were lying about what happened in the jail before the Friday start of the trial?
What do you mean?
Well, so let's talk about it. We had multiple individuals who testified about your desire to not come to court, correct?
I know at least one said that, and I do remember making a comment, I don't want to, but most of it was I can't.
Okay, but you did say the words, "I don't want to." Is that a yes?
Yes,
And you ultimately memorialized that in an affidavit.
yes.
And you don't dispute that that is something you signed, correct?
No, I don't dispute it, that's something.
Do you remember? Actually, I'm gonna strike that. Let me rephrase. Ms. Kentucky testified about her observations of you
Yes,
that morning, correct?
yes, she did. Although hers were different than Fred's and mine, but some of them.
It's fair to say you have some selective memory about what you remember from that morning, correct?
It's not selective at all. I still have memory issues to this day.
So it's fair to say, though, you remember some of the things, enough to say Ms. Kentucky's is different than yours.
Well, because I sat there and I was the one that wrote the affidavit. And I sat here when Mr. Johnson said that, and officer said that I was curled into a ball on the floor, and then she said I was up in a chair, that it wasn't as bad. But he described it. I mean, the most accurate total description was what he did, what he described and the officers described. Hers wasn't as accurate.
So you're saying that Mr. Johnson's description of you that morning is accurate?
From what he said, as far as curled up into a ball and not able to communicate, yes.
So I said yes or no. Mr. Johnson's testimony about that morning is accurate.
As far as I remember I'd have.
Yes or no?
Yes.
Okay, thank you. I have nothing further.
All right, Mr. Ambrose. Are you saying all of Mr. Johnson's testimony was accurate?
Absolutely not.
Okay,
Not even close.
all right. You were seen by a number of professionals, correct?
Yes, sir.
One of those professionals is Dr. Valentine, is that correct?
Yes, sir.
And the prosecution mentioned that on page 10, there is a conclusion part, and you testified as to that, is that
Yes,
correct?
sir.
The ultimate conclusion on page 11 of that Dr. Collins report Can you read that, the highlighted portion?
Yes, sir. After reviewing the text messages with Ms. Vander Ark and the police report, Ms. Vander Ark continues to insist that she did nothing wrong and was not convinced that her actions and instructions caused the death of her son. This clinician is of the opinion that Ms. Vander Ark truly believes that her actions were appropriate and not harmful.
Okay, and this is a report that Mr. Johnson gave you?
Yes.
And you talked about this with Mr. Johnson?
I don't remember how much we talked about that.
Okay. As far as you're aware that you've always expressed your innocence to Mr. Johnson.
Absolutely.
Did you ever concede or ask him to concede to anything?
Absolutely.
All right. Now, after day 3, after your testimony, were you seen by any medical personnel?
No.
On day 4, were you seen by any medical personnel?
No, sir.
I have nothing further.
No, you're not. Thank you.
I have some questions. Ms. Vander Ark, I think you testified, giving your testimony for Mr. Ambrose, is that you said on day 1, Mr. Johnson told you that you had to testify. Is that true?
No, I said I knew I had.
So you knew you had to testify?
Yes, sir.
Okay. And did that conclusion come from the conversation between the two of you? Or was that something that you were already had concluded in your mind even before you talked to him?
I think it was mostly I concluded, I mean, we discussed it, but I kind of knew that from the first time.
So you knew it, so you're telling me this idea of you testifying came independently even before you had spoken to Mr. Johnson?
Yes.
And then did Mr. Johnson discourage that idea? Did he encourage that idea?
He agreed with me the whole way. We talked about that multiple times and the whole process. And we always said I had to testify. There was never a question.
You said that Mr. Johnson, the discussions between the two of you had largely centered around that the prosecution had to prove intentional acts. Is that true?
For the child abuse charge, yes.
Okay.
Intentionally.
Intentional and knowingly. Okay. And you said you two agreed that, based on what you were telling him, that intentional and knowingly had not occurred.
That's correct.
Okay. Was there ever discussion after that about, well, it's potentially, there could be a negligence argument here?
No. We
Never talked about negligence?
Never.
Okay. You had indicated that you saw Mr. Johnson, you said around 2 to 3 times during that first month after you were arrested and taken to the jail. Is that correct? Okay. After that, you used the phrase, I saw him once in a blue room. Can you give me an approximation how often that you believe you saw him going forward? Once a month, twice a month?
It wasn't. I think when he testified, he said once every other month. I don't feel like it was even that often.
Okay,
But I
so
don't-
what's your independent memory of how often you came?
I would say once every few months.
Once every few months? Few meaning 3 months?
At least 3, yes, sir.
So once every 3 months? All right. Did that frequency increase as the trial approached?
I don't feel like it did. I mean, there was a couple at the end that were closer together,
Okay.
but
The month before the trial, can you tell me how many times you remember him visiting you?
there was 2 actual visits, and then we came in here for 20 minutes
Okay.
to do a few minutes.
I want to make sure, I should have prefaced what I was saying. When we're talking about Mr. Johnson, I mean himself,
Yes,
not any other member of his team.
no, I mean,
Okay, so those that you're testifying to was Mr. Johnson himself, is that
Yes.
correct? Okay. Were there any other members of his quote-unquote team that had come and talked to you outside of those times when Mr. Johnson had come individually? So separate from Mr. Johnson?
You mean just before trial, or what do you mean?
No, well, let's start, you said 2 or 3 times Mr. Johnson the first month. Was there anybody else from his quote-unquote, let me go back. What did you know of his team? What did you consider his team to be?
I knew he had some interns. He had the original social worker, I don't remember her name, I'm sorry, I'm bad with
So
names.
social worker,
She came in once a week to the jail for a while.
okay, once a week, okay.
And then that was it. We came in for a hearing, I think it was to something about competency, and Nick Goings was there.
Okay,
So I knew he was on the team. And then both the social worker and Fred had mentioned a research attorney.
okay. Did you ever meet the research attorney?
I didn't.
So you believe 2 interns, research attorney, at least one other attorney, Mr. Goings, and you believe he was an attorney, correct?
Yes, oh, I knew he was.
And Mr. Johnson, is there any, and the social worker, was there anybody else that you knew was on this team?
Not specifically. I mean, he would say he had people working on it with us
All right, and you're saying the social worker came in every week?
for a while, then before that one left. She left the public defender's office.
Okay, do you know approximately when she stopped coming to see you? Okay,
I'm sorry.
that's okay. And then when a new one took over, did that social worker come?
I saw her twice, I think.
Twice.
Before trial.
Okay, all right. In terms of the interns, how often did you see an intern?
They actually did not come like he had said they would.
They never came?
One came with him, it was the same one a couple of times.
Okay,
I don't know, 2 or 3 times, it was there at the end, she sat in on the trial too.
so did an intern ever come independently of Mr. Johnson?
No.
Okay. I read your affidavit. One of the arguments advanced by your attorney and you in the affidavit was that Mr. Johnson did not argue what you felt. Well, let me ask you a question. The dehydration argument, was that to you should have been the primary argument?
I did not even know about that until the medical examiner testified.
Okay.
So when I realized that, I asked him to ask about it, but I think he only asked one question, and that was it. I didn't even know about that until that day.
Okay, in your affidavit, it says, and this is one of the paragraphs, this is page 11. It says the medical examiner stated that one of the main causes of death was dehydration. It says, I specifically asked Mr. Johnson to examine this much deeper. There was no accusation against me regarding depriving Timothy of water. This alone could have raised a reasonable doubt that Mr. Johnson never pursued this subject at all. When you make the statement, I specifically asked Mr. Johnson to examine this much deeper. Are you saying was this before the trial, or was this after you heard the medical examiner testify?
This was after I heard the medical examiner testify.
Okay, so it's your testimony, and when you said you asked Mr. Johnson to examine this much deeper, was that during a break after the ME had testified?
No, it was in the middle of it, I wrote him a note.
Or you wrote him a note?
Yes.
Okay, do you recall what the note said?
I put dehydration question mark exclamation point. And I said, please ask more about this, because
That's
he
what
had
you wrote
access to water, yes, sir.
Okay. And it's your testimony that he did not?
No.
Okay. Right. I don't want to go too much into what could have, should have. Did Timothy have access to water?
Yes, he did.
Was he cognitively capable of getting water on his own?
Yes, he was on the spectrum, but the only symptom he really showed was awkwardness. He was grade level, he was passing all his classes. And, you know, he did interact with some people at little man's baseball games. But he just was awkward, he didn't want to hang out around other kids. And he was 15, he was, you know, he tried to hug him, he's like, Mom, go away. But no, he could communicate just fine. Trust me, he could communicate just fine.
And I just want to be clear what you believe the argument that should have been made. You believe the argument that should have been advanced to the jury was that Timothy caused his own death by not drinking water.
I mean, I think that something should have come up, there was, and I just told him that.
Well, hold on. Is that the argument? Is that the argument that you believe should have been advanced to the jury, that Timothy caused his own death because he stopped drinking water?
I think it should have been mentioned, yes. He had suicidal stuff before I got him, so.
So he had suicidal stuff?
Yeah, he was actually hospitalized for suicidal ideation, his stepmom told me that.
Okay. So you believe that an argument should have been made that Timothy essentially consciously caused his own death? He was suicidal, he committed suicide.
I mean, I don't know what happened, so.
Well, I know that, I understand that, but I'm trying to
It should
understand.
have been brought up, yes.
Okay, all right, I understand. Okay. Did your concerns with Mr. Johnson's representation, did those arise prior to the trial?
I was worried about it along the way, yes.
Okay. Did you ever attempt to bring those concerns, to the court's attention?
No.
Okay.
I wasn't in good shape. Remember, the time I was isolated, I wasn't eating, I wasn't sleeping.
Okay.
I was not in good shape.
Did you have the ability to write letters, correct?
Yes, but I didn't have any, I mean, for the most part, at first I had a little bit of money on my account, but I didn't have any,
Well, you can write cuts, correct?
Yes.
All right. Those are free, correct?
Yeah, you can write them, they go to your attorney.
Were you aware that you could send one to the court?
No. I was not.
Now, you were in court a couple of times before trial, is that correct? All right. Is there a reason you did not bring that issue to the court at the time of those hearings?
I didn't want to speak out of turn. I mean, I wasn't thinking about it right then, but I just, those hearings were for certain purposes.
So you didn't feel that you could directly bring those to the court's
Yes.
attention? All right. Just below that paragraph on page 11, it says, I testified for around 5 hours at the Thursday trial. I was supposed to finish my testimony on Friday, including some very important questions that I wanted Mr. Johnson to ask me before I finished testifying. Do you recall what those questions were?
For the most part, no. I remember one of them because I lose weight really fast. And so, I know there were some questions about Timothy's size along the way. And then we also talked because he's 6'1" and was like 130 pounds, and I'm small. And I was gonna have him ask me about how quickly I lose weight, because if I don't eat for a day, I'll lose a couple pounds that fast.
So
So I wanted him to bring that up.
So you wanted to ask how quickly you lose weight?
Yeah.
Okay.
Well, family genetics, I mean, my mom did the same thing.
Okay. Now, any other questions that you could recall?
Not that I remember now. I didn't have a pen or paper to write them down. I didn't have that available when they put me down in the holding cell. What paper I had, where I was at, I didn't have access to it.
Okay. These questions that you had contemplated, those were, I'm trying to figure out when you formed those questions in your mind. Was that on Thursday or was that on Friday?
Thursday afternoon.
Thursday afternoon.
Thursday evening, yeah.
Thursday, okay. At the time that these questions were formed, were you suffering from a panic attack?
No, it was after that.
Okay. Friday morning, did you formulate any additional questions?
Not that I remember.
Okay. I want to know there's a lot of in your affidavits about what was going on in the holding cell, that you curl up into a ball, you're barely able to communicate. You asked Mr. Johnson to postpone the trial, and you recall what his response was.
Yes.
I want to know, do you independently remember that, or is it what your affidavit, is that based on what someone else told you?
No, I remember that small portion of it. I remember bits and pieces, because I remember other parts of the morning as well, but that's it.
So
I remember laying there. I was curled up, because he testified that he had explained options to me and he did not. I asked at least 2 or 3 times to adjourn because I couldn't do it. And he said that, it was just gonna be the same and that they just go on without me.
okay, so those things you can remember, but other things you don't remember, correct?
Yes,
Okay, so during these panic attacks, it sounds like you have, if I say lucidity, you know what that means?
yes,
Okay, so you're saying during these panic attacks, there are brief moments of lucidity during these panic attacks, where you remember, where you can cognitively understand what people are saying.
Not usually during a panic attack. It wasn't one solid panic attack. It was multiple panic attacks at once, but there was times where I wasn't actually in the middle of a panic attack.
So you're saying that these, what you recall independently of these communications, is when you were not suffering a panic attack.
Yes.
So the recollections that you have are from non-panic attack instances, correct? That's all the questions I have. Ms. Vander Ark. Any follow-up, Mr. Ambrose, to those questions? Mr. Ambrose?
As far as you're aware, when was the last time that either you or Paul provided food to Tim?
I want to say it was the day before he passed. I think Paul said he'd given him something.
Okay. All right, I have no further.
Any follow-ups?
So Ms. Vander Ark, it's your testimony that Mr. Johnson should have probed dehydration, correct?
Yes, he knew about it the whole time and never was with it.
Well, you in fact knew about it too, correct?
What do you mean?
Well, let's go back. Were you at your preliminary examination?
Yes,
You attended it?
yes.
And do you remember the testimony of Dr. Joyce DeYoung,
At the preliminary? The medical exam?
the medical examiner?
I don't remember her testifying.
Do you have any reason to contest the certified transcript of the preliminary examination?
No,
And in fact, on page 87 of your preliminary examination, the forensic pathologist testified his cause of death was dehydration and extreme emaciation due to malnutrition and starvation. Any reason to contest that?
no, I don't even remember her testifying.
Now, there was also, I'm sorry, I cut her testimony off short though, but a significant contributing factor of exogenous hypothermia, so exposure to cold, end quote. Any reason to contest that?
No, she's the medical expert.
The reason he had hypothermia is because he was in water for hours before his death, correct?
That's not what Paul told me. Paul he had run.
I didn't ask you what Paul told you.
If that's what
The evidence showed that Timothy was in an ice bath for hours before his death, correct?
Not the whole time, because we didn't have enough ice for that.
Okay, well, let's go to this. You had an ice maker on your counter at the house, correct?
Yes,
And that ice maker was used to put ice cubes into a bath, correct?
yes,
And you were aware of that.
yes,
And ice is technically water, correct?
yes,
And bathtub water is water, correct?
yes.
So yes, it's fair to say you did not restrict his access to water when you ordered ice baths, correct?
I'll go with it. That's a really weird question. but I'll go.
Well, okay. You weren't keeping him dry by ordering ice baths for him, correct?
That's a really weird question.
Well, ma'am, you are saying that Timothy committed suicide by not drinking water.
I didn't say that. I said it was possible and it should have been explored because of his previous history.
Well, do you understand that if it had been explored, that there'd be further questions about the ice baths?
I don't know.
Because naturally a bath contains water, correct?
Yes,
Which was a punishment that you ordered for your son, correct?
once or twice, yes.
Now, you also said that your attorney asked you when was the last time Timothy was provided food. Do you recall that?
Yes,
Do you recall having conversations about putting food in front of his face and pulling it away?
no, I don't.
But you have no reason to contest those text messages, correct? I'm sorry, let me finish my question before you answer, okay? You have no reason to contest those text messages, correct?
Correct.
And so if they say that you said to essentially tease your starving son with a pizza roll, that Paul should do it.
If that's what it said, I'm not contesting.
You also ordered that he be provided hot sauce, correct?
Yes,
Okay. Is that the food you're talking about with your attorney, saying you provided food?
no, not as far as I know.
You also ordered that he could have hot sauce placed on his genitals, correct?
That's what the text messages says.
Is that the food that you say you provided to him before his death?
No,
Now, the medical examiner didn't determine that your son died from suicide, correct?
that's correct.
But now you're here telling the court that he was suicidal.
I didn't say for sure he was. I said it never got raised.
Well, you sort of raised it in that video that you said that your attorney should have played, correct?
What do you mean I raised it in the video?
On the morning you discovered Timothy was non-responsive in that closet. Okay, are you following along with me? So that morning, when you discovered he's non-responsive in the closet, you have discussions with Paul about telling authorities that Timothy was on a hunger strike, correct?
I'm not disputing it, so.
Did you, in fact, tell Paul that we need to say he's on a hunger strike?
I don't remember. If that's what was in there, then I'm not contesting it, but I don't know. I don't remember.
And now you're saying he was on a drinking strike too, correct?
I'm saying it should have been explored. There's a big difference.
This is just another scheme of yours to try to blame Timothy for his own death, isn't it?
Not at all. There is no scheme.
Okay, maybe not the right word. Your testimony is blaming Timothy for his own death,
I'm not
correct?
blaming anybody. I'm saying there's possibilities that should have been raised.
Well, you're saying he was,
History of suicidal.
so you're saying he was suicidal.
I don't know. I never even thought about the possibility until that morning in court. Because I honestly do not remember the medical examiner testifying at prelim. I don't.
You didn't think about the possibility until you were trying to find out a way to blame Mr. Johnson to get a new trial, is that correct?
No, that's not true.
I have nothing further.
Have you seen the death certificate?
Yes. I didn't see it till that morning.
Until when?
Until the morning I testified.
Okay. Do you recall what the first thing that is listed on this death certificate is?
It's dehydration.
All right. And that's kind of strange, right?
Really odd.
Because he's in an ice bath, right?
Mm-hmm.
And he has access to water, right?
Yes.
And so
He didn't.
he didn't drink.
No.
You never prevented him from drinking.
No.
All right, no further questions.
Okay. Oh, that prosecutor. She makes me so happy when she gets back up there after the judge questions her and starts asking her those questions again. Like, really? Okay, so this is what you're really doing right here? Ah. Oh, I so love it. Like, I live for that part. Like, I hate that it comes all the way to the end when she actually goes in regards to this ice maker and stuff. But boy, oh boy, talking about stopping that old mess that she trying to do. Okay, so let me get this up for us. Okay. So basically what we have here is we kind of went over some of the things that the judge had denied it for. So the competency argument was rejected. Shanda argued that she was not competent during the trial and that procedures weren't followed to protect her rights. The judge found that testimony from her trial attorney, Fred Johnson, and other witnesses showed that she understood the proceedings. She was able to assist with her defense, and while she may have experienced some emotional distress and anxiety, that did not make her legally incompetent, okay? The judge specifically said that Shanda's testimony was not credible. and referred to her claim for her memory lapse as selective and self-serving. As we can see, like I told you, she never fell out when I needed her to fall out. Like, it was different points of times. I'm like, okay, I need you just to fall out, flat out on the floor. You think that happened? No, of course not. She doesn't listen. So, ineffective assistant of counsel rejected. Shanda claimed that her attorney made several serious mistakes. The judge addressed each one. Expert witnesses, right? The defense argued that Johnson should have found an expert to support Shanda's memory loss claims. The court noted that 3 separate experts came. They all looked at her and they all came to the same conclusion. That's not the case. Like, she is not mentally ill. She's not suffering from any of these things. So none of them supported her claim. So even if they would have put up the 3 witnesses that they had for her, nobody would have supported her claim. She needed TT's doctor in here to help her. Okay. Because TT's doctor, she would get up there and say any old thing to support her client. So maybe they should have reached out to her. Now, cause of death strategy. And that's where, let me see, where did he address it in here? Okay, here we go, right here. So the cause of death strategy, defense argued that Johnson should have, which is her attorney, should have focused more on dehydration. The judge found that Johnson intentionally chose a strategy focused on the intent versus to the negligence and called it a reasonable trial strategy. So nothing was wrong with it. It seemed like what she's trying to say, and that's why the prosecutor jumped back on her, like, are you really trying to say, like, he forced this, he committed sewer slide because he didn't want to drink water? So, even when we talk about this thing, the judge, you heard him ask, like, was water not available to Timothy? And she said, no, of course it wasn't, because he was in ice cold baths, right? He was submerged in waters. So I think in her mindset, he always had water. I guess he's supposed to drink the dirty bath water or drink the ice cold water or try to figure out how to shiver through it. I have no clue. So in regards to failure to object, the judge found that even if some of the testimony could have been challenged, Johnson's decisions were reasonable and it did not prejudice the defense team. So, and regarding to the objection of the Lieutenant Joe, who was called to describe the video of the victim hours before his death, she lucky because they really wanted that video in, but somehow her lawyer worked hard enough to get that video out. So, of course, the court disagrees. Following the statement at issue, Lieutenant Joe, the victim appeared to be unresponsive, and he did not speak at all. He moaned a few times, but that was just what he's seen in the video. What they should have did is just let it play. Then what? The next issue that they have in regards to this, her conceding involuntary manslaughter. One of the biggest complaints was that Johnson argued she was guilty of involuntary manslaughter rather than intentional murder. The judge ruled that this was a legitimate trial strategy because the evidence was overwhelming and Johnson was trying to avoid a first-degree murder conviction. So his basic thing was like, look, let's do involuntary manslaughter. She is guilty of involuntary manslaughter because she did not know that keeping him in the closet, not feeding him, giving him hot sauce on bread, all of these things, she did not know that he would pass away from this. So the judge just said that Johnson never conceded guilt or intentional murder. It was just, part of the thing. Now, a few statements that I found that that stood out. The judge called Shanda, of course, an incredible historian. It's a different way. It's like calling a person a liar, but I guess in a professional way. And said her testimony was so unconvincing, and we know how she testified in the first trial. You know, with her fake, I guess they called it dry heaving, whatever that is. That little stunt that she played on the thing. Even if her lawyer had made any mistakes, the judge found that there was no reasonable probability that the outcome would ever change. Like, it is what it is. And the judge also found that her amnesia is very selective. And, you know, for those reasons stated above and things that we talked about today, and us even watching her testimony, it was denied, you know. And I think that a lot of people, when we first watched the hearing, they were like, well, is she gonna get a new trial? Is she gonna get a new trial? Is she gonna get a new trial? That was a lot of the comments. And, you know, when will you know? When will you know? When we know? Well, now we know. He denied it. I don't think this is the end of it. She probably can go to like the Supreme Court or something. She'll find something in here. But yeah, such a mess of her. But that takes care of our coverage that we have on Shanda. Give me a second. Let me look and see if our military murder trial has begun yet. I'm not sure if it has begun. Let me check and see. No, it hasn't. Nope, it has not began yet. So, and yet, our boat trial has begun. I'm looking at where they at in the boat trial. Okay, so what we can do here is we can, yeah, it's all bad for her. And rightfully so. Okay, what we can do is one or two things. Our military trial has not started. We could flip-flop watch the boat trial now and go to the military trial afterwards, or I can wait until the military trial starts and we can go into the military. How do you want it? How do you want it? How do you feel? I'm doing Tupac today. Rest in peace. Because I think the boat trial, the military murder trials with one. But like I said, they haven't started yet. So, I don't mind. We can end this stream, and once they start, we can go in there. Unless y'all want me to start it, and if y'all want to rewatch some testimony or something. I meant to enhance that audio on that. If I went into the boat trial, we could do comments. We have to do it like I can't be live streaming with them at the same time. So like if we start with the boat trial, like say for instance, they started at 6:30 this morning. If we started at 6:30 in the morning with them, I cannot. That's at least my understanding of all this. So I think delay kind of gives it to us. I don't know. And I've probably been doing it all wrong anyways, but yeah. Definitely be part of it. Of me doing it all wrong. Because what I've been doing is I've been streaming it after court shut down and nobody's in there. And then I'll stream it and put on the comments. So we'll see. I know. I don't want to get dinged for it either. I don't know what is going on. Like, it's so much misinformation. Not, I don't want to say misinformation about it, but it's that we can't live chat, right? Well, we wouldn't technically be live chatting, depending on what's your definition of live chatting, because the court started for about 2 hours. So we technically wouldn't be live chatting, if that makes sense. Oh, if that makes sense. Like, some channels are showing it at the same time, so they're not live chat. I don't know. I've been putting our live chat on because we've been covering it later in the day. So if we cover it later today, I will do it. I will have chat on, just like I did the other day. Yeah, because I don't want to get in no trouble. Yeah. Let me see what we got here regarding our guy. I wonder how many more days that trial, the boat trial, gonna go for anyways. It should be nearing the end, right? I think. Maybe. No, maybe not. Okay, it looked like they are starting the courtroom for the military marriage one. Okay, cool. We're gonna go into that one. Okay. We are gonna go into that one. Let me go ahead and finish. I'm gonna get that one set up. We'll go there. They just opened up the feed. I just got the alert on my phone. Give me 1 second here. Here goes some music while I get our room together. And then I'll drop the link and we'll go over there and watch it.
Whoa, yeah. Courtroom packed and the cameras on. Folks all whispering won't be long. No more smirks and no more lies. Judge looked down with narrowed eyes. Bailiff waiting by the side door. Steel-toed footsteps on the courtroom floor. Whole chat buzzing like the verdict dropped, but the jury room still got them locked. Hear the cell doors locked. No parole boy, baby, round the clock. One-way trip and the bus won't stop. Everybody clap to the L-Wop-Bop. L-Wop-Bop. No appeal gonna save you. Orange jumpsuit, tailor-made flavor. Sink that feeling when the gavel drop. That's the rhythm of the L-Wop-Bop. That's the rhythm of the L-Wop-Bop. Mama crying in the second row. Defense still talking, but it's moving slow. State brought receipts and the pressure's steep. Now the whole room barely even breathes. Used to talk big for the TV lights. Now it's long breaks and uneasy nights. Funny how the swagger disappeared before a single word got cleared. L-Wop-Bop-Bop. Hear the cell doors lock. No parole board, baby, round the clock. One-way trip and the bus won't stop. Everybody clap to the L-Wop-Bop. L-Wop-Bop-Bop. No appeal gonna save ya. Orange jumpsuit, tailor-made flavor. Sink that feeling L-Wop-Bop. Case pause, courtroom tense. Everybody waiting on the consequence. One deep hush through the parking lot to the beat of the L-Wop-Bop.
Okay.
Whoa,
Okay, so as you can see, I dropped the link in the chat. I did put on a redirect, so it should be putting us, it should, after I end this stream, it should take us all over there. I want to say shout out to the mods, shout out to the chat, shout out to Susie and Drunky for all the gifted membership. Remember, if you received a gifted membership, to say thank you, even if you're on a replay crew. I definitely see the comments and I definitely try to let everybody know. We truly appreciate it. I will see you guys over in the military murder trial room, and we'll get started with day 3 of that one. We're all caught up with that one. And hopefully we won't have to do anything more on Shanda. Hopefully for a long, long, long time. All right, guys. Peace.